So, we're on the fifth heading of the narrative of misconduct. Mr. Manduka's breach was found by the judge at page 143, paragraph 292. An arrangement in place between January and dissolution for Mr. Manduka to share in 30% of Newfoundland profits. It's common ground that if that finding was made, Mr. Manduka disputed it, but accepts he can't challenge it, of course, given the limited scope of review of the actual finding. What there wasn't was a finding that Mr. Manduka was in partnership with Newfoundland or with Freddie and Mike Hodnett. I mention that simply because I think Ms. Hilliard suggested that yesterday or on day one. So it amounted to an agreement with a downstream customer, namely Newfoundland, to take a share of that customer's profit. Ms. Hilliard also told you that there was no finding of breach against Mr. Hughes. That was in answer to my Lady Justice Falk at page 18 of the day one transcript. That's, I put it like this, an oversimplification, to put it mildly. I've already shown you to part of what the judge found in relation to Mr. Hughes' actions in June, starting on or around the 14th of June. To summarise, and we'll look at the references in a moment, but to summarise, these consisted of steps taken in combination with others, denigrating Mr. Manduka to the exclusive and lifeblood supplier of the business, Acon, making allegations against him which were not correct, incorrectly stating that Mr. Hughes' company owned the name and the IP, and doing all of that with the intention to cut Mr. Manduka out of any future dealings with Acon. So not just to terminate, but to cut Mr. Manduka out and to deprive Mr. Manduka of any share in Mr. Hughes's future dealings, which he intended to and did seamlessly continue, as the judge found in very large capital letters. And at the same time, doing this to shore up Mr. Hughes's position with Acon. So we looked at the judgment. We won't go back to it at page 124, paragraphs 200 to 202. You can see in our bundle, our unagreed bundle, at page 44, which is tab 10 for anyone using tabs. The start of the WhatsApp chain. So the first from the unspecified participant is Mr. Hughes. I think the judge recited the first of those. And then fourth down, he says it won't affect the DPS, that's the platform for government tendering. Ms. Shui replies, as you see, in effect repeating what Mr. Hughes has pretty much said in so many words. Partnership's not going to go on. Then she asks, so they will know from your system that we send you tests without them involved. So one notes there that immediately the understanding is we, Acon, are going to carry on supplying tests. Not, it's all over, we're going to go to someone else. Mr. Hughes, again, we say wrongly, carries on harming the position of his partner by saying they have no visibility. And the immediate question, which Ms. Shui asks in the context of her sending tests or in the future, which entity holds the IP rights. And he says Hughes is with me. Then she says, I'm checking because I don't want to be sued. So absolutely the point that my lady made, but in my submission, for a practical reason, because they are contemplating future supplies. That's why they might be sued if they weren't contemplating future supplies. Now, annoyingly...
Sorry, yeah, that's a slightly different point, isn't it? What we were discussing earlier was whether this indicated that Acon placed these counterclaim men.
Yes, and that's the brand, Hughes brand.
Mm-hmm.
Yeah. And then by one of those quirks that so often happens, the last two entries have chopped off, but fortunately we can pick them up from page 67 in the same bundle, where they're extracted in my client's trial closing. That's tab 20. I apologise for that, we realised it. Too late to change the bundle. If you go to page 67, tab 20, paragraph 370 towards the bottom of the page, you will see an extract of the first messages, but then you can see Ms. Shui's comment ending without authorization. That's the bottom of page 44. And then the reason I'm showing you this is what Mr. Hughes says, which is that all the previous sales have been to my company. So again, not correct, perfectly plain, not disputed, that in fact the sales were to the partnership. And that's just indisputable on what was common ground by the time of the trial and what the judge found.
Well, I'm sorry, they were strictly to Hughes Group Limited. Hughes Group Limited was always the counterparty. That they always placed the orders with Acon. But I accept that as far as Mr. Hughes and Mr. Manduka were concerned, they were in partnership buying tests, using Hughes Group Limited effectively as their, Mr. Hughes using HGL as his agent for the benefit of the partnership, buying the tests. But the tests were always bought and sold, always bought and sold by Hughes Group Limited. I'm not sure it makes any difference, but that's the correct.
Mr. Hughes, in my submission, commercially carrying on soliciting for his and securing for his benefit the partnership business connection with Acon. That's what he's doing here. That's what all of this is directed towards. Doesn't matter that it's not exclusive in law. It doesn't matter that there's not a binding contract. It doesn't matter that in some circumstances Acon might sometimes deal with someone else. What matters is that this was critical relationship from the partnership's point of view. It was a relationship, undeniable. They've been buying from Acon and doing all sorts of other things with them for the best part of a year. And that relationship is now being suborned or taken by Mr. Hughes from the 15th of June, as we'll see, as the judge found was essential in order for Mr. Hughes to implement his plan, which was to take over the business without any accounting to Mr. Manduka, his 50% partner, who'd actually brought the whole idea to him, and in addition to other things, had got Acon through the port and down test when it had been excluded, without which there wouldn't have been any business. I should just say, by the way, my lord, on the CE mark, I'm displaying here my lack of detailed familiarity with the retained EU law regulations and all of the other fascinating jurisprudence that we've been gifted as a result of the 2016 referendum. The CE mark, and I can't give you chapter and verse, but I'm told that it is part of EU law that continues to apply, or at any rate did at the time of the pandemic, so that the effect of it, I'll be able to give you more detail if we need it. The effect, however, applied in the United Kingdom, notwithstanding that we had left the European Union on the 31st of December 2020. And I think I may have showed already, just for your note, the judge recorded at para 122 that it was part of the increased saleability factor for Acorn, as obviously it might be. Now, the judge then summarised what he thought about and found rather about Mr. Hughes's conduct at that time in the judgment when he page 128. So 224, he refers to a significant dispute between the parties as to the plans, intentions and beliefs. Sets out the claimant's position to bring the partnership and then with a view to Mr. Hughes or his companies carrying on the partnership's business for themselves. That's 224(1). And then 225, the defendants argue there was no preordained plan and it was just a final straw on the 25th and 26th of June. 228, the judge reaches his factual finding, which I think I showed you earlier. But the critical point here is Mr. Hughes' second sentence took care to tell Anita Schwave what he thought was going on and to assure her that Hughes is with me, because he realised that securing a supply of Hughes healthcare brand test in the future was crucial to his ability to continue the business. And we say that itself is powerful evidence, powerful findings supporting the simple fact that this company, Acorn, is part of the partnership's, a critical part of the partnership's business connection. It's the sole supplier of everything that the partnership sells, and it remains part of its business connection, whether or not there was legal exclusivity or various other factors, which we say is simply not the test and shouldn't be substituted. Now, he then concludes at 232 that Mr. Hughes and others, his wife and the two companies, were party to the kind of plan that the claimants allege from around 15th of June 2021. He leaves out Mr. Butcher's participation because they're separate proceedings. He says the plan and the, quote, war that followed it would have made no sense if there was to be an account of benefits received from taking over the business to either the partnership or Mr. Manduka. Moreover, no account of benefits has been offered. I accordingly infer that all participants in the plan realised that a necessary ingredient of it was the absence of any form of account to either Mr. Manduka or the partnership. So the whole object of what goes on, what had been set up by these secret unilateral communications with Acorn in the middle of June and then put into place with various other things that happened around that time, was to ensure that there was to be no payment to Mr. Manduka, no form of accounting. I've already shown you that back in as long ago as February, that's paragraph 148, Mr. Hughes had earlier secret communications with Acorn, damaging his partner's standing. So we say that there was fault on both sides in this relationship. Now,
the end of 233, there's just a reference to the relative sizes of the Newfoundland and partnership business. Picks up a question my lord asked earlier. Do we get any help from that, or is that a reference to something else in the judgment? I seem to remember seeing something, but I can't place it.
Can I come back to you on that, my lord? I'll consult with everyone to make sure I can give you a simple answer. Mr. Hughes, I should have said, I'm sure your lordships and your ladyship have picked this up, also excluded access of Mr. Manduka and his camp, his family, to the Hughes healthcare email accounts. He first did that on the 15th of June, shut them out, and then was prevailed on to restore it, and then did it again on the 22nd of June. So that in modern form is equivalent to the classic case that you might find in a Victorian situation where someone's literally locked out of the building. There were also, just to be complete, so that we don't want to be accused of selectivity, the judge did consider allegations of diversion. I can summarise those in this way, that he found that he considered 18 allegations, plus one that wasn't pleaded. He found that there had been sales for only two, which were 2000 and a company called Signpost, spelt with a C. I don't want to take up time going through it in detail. It's dealt with in some detail, starting at page 152 and going up to page 161 of the bundle. One can see that there were, in the cases of both of Digital 2000 and Signpost, reasons why it might have been thought that it was a Newfoundland contact. The judge found 4 other cases where no order resulted, but there had been a sort of diversion, but potentially leading to some loss of a chance. But in 11 of the cases that were mentioned, he found no breach at all. The Hughes Healthcare Limited, despite the efforts of my friend and her team at trial and in seeking permission, very firmly found by the judge not to be a breach. It was a company. There was another Hughes, a Dr. Hughes, who had a company. It didn't become possible to buy it from him. It got dissolved. Mr. Manduka was able then quickly to register, and the judge found that was all above board. Completely rejected the allegation that was made that that was some sort of improper conduct. It was, however, the trigger, as a matter of fact, for Mr. Hughes's decision or part of the trigger for Mr. Hughes's decision to seek dissolution. The judge at page 130, paragraphs, and this is part of what Mr. Lord Justice Snowden was referring to, 233 to 235, the judge dealt with Mr. Hughes's concerns at the time. He found that the concern 234, second sentence on page 130, the concern about the establishment of HHL was wrong and unreasonable. In the case of the response to, in the case of the concern expressed about the Indian dealer, the judge found that it declined to find that Mr. Manduka had done anything or planned anything that was wrong, but he held that Mr. Hughes had some grounds for concern. From his perspective, it was reasonable, but finally, in relation to the size of the Newfoundland business, Mr. Hughes was, as the judge put it in paragraph 235, in the pre-penultimate sentence, 4 lines up from the bottom, wide of the mark, because most of the leads that were said to be diverted were actually contacts of Newfoundland, and under the demarcation agreement, Newfoundland was perfectly entitled to take them. And so that, as the judge found in the 3rd sentence of this paragraph, 4 lines down, overlooked the fact, etc. It was then against the background of those beliefs, which were none of which were found to be correct, one of which was found to be unreasonable, and another found to be wide of the mark, that Mr. Hughes then formed the plan that he did, which led him to take the steps, wrongful steps that he did, which the judge outlined that I told you about earlier. And that then led to the dissolution notice or email on the 27th of June. And then post-dissolution, last chapter, the judge found that paragraph 405 on page 168, the appellants sold 63 million tests post-dissolution. So 8 million was the initial Danish order, which was branded, although that wasn't something the Danes wanted, but in fact it was branded, Hughes branded. 35 million was then the second Danish order a month or so later. That was unbranded, as in they carried the Acorn brand. And so that makes 43 million, and that leaves 20 million to others, which we can see the judge dealing with at paragraph 406 and following. That's on page 169. You can see at 408, reference to UK wholesales that had been a customer of Newfoundland. You can see that was also obtained by information obtained from a review of emails, 409, that Mr. Freddie Manduka had sent on a Hughes email address. 410, there was a meeting, Hughes and others, Mr. Butcher and one other, travelled up to Manchester to meet this customer. During that meeting, Mr. Butcher and Mr. Hughes indicated that only HGL could legally sell branded tests. Newfoundland was acting illegally in doing so. Hughes Healthcare was obviously the name of the partnership. They wouldn't have made that assertion unless they thought it would have had some effect on UK Wholesale's purchasing decision, and the judge infers that it did have that effect. So there you have a very large order, 200,000 at 150 each. So what is that? £300,000 order, and that is obtained by going up to Manchester, having got details of the customer and telling them that only we can use the partnership brand name and no one else can. Boots. Wasn't previously a client of the partnership or Newfoundland. 413. The judge concludes that that came about because of a combination of at least two factors. So Polly Phillips, who was a new recruit that Mr. Hughes had brought in finding contact details of the appropriate decision makers at Boots. And second, in those conversations, MSDL would be able to stress that they were selling the market-leading Acorn LFT. And then he says, as with my similar conclusion in relation to the Danish deal, neither of these considerations predominated. As he says at the bottom, even once she'd secured access to the right people, sales would have been unlikely if MSDL was trying to sell the wrong LFT. That was a short-lived relationship because Mrs. Manduka wrote to Boots, as you can see from the next paragraph, indicating that Mr. Hughes's companies weren't entitled to sell under the Hughes Healthcare brand, and then orders from Boots dried up. Should also draw your attention to 412, second sentence, an email exchange this is between Ms. Blythe, now Mrs. Hughes, and someone at Boots in October. Mrs. Blythe confirmed in her evidence that MSDL sold some LFTs to Boots UK and that the LFTs in question were manufactured by Acorn, a business connection of the partnership. PFW labels at paragraph 415, that was a previous customer of the partnership. You can see at 416 on the 2nd of July, so that's a few days after the dissolution, they send Ms. Blythe a purchase order for 1,000 Hughes 15-minute test kits. That purchase order named the supplier as Hughes Healthcare. Ms. Blythe arranged for the invoice to be issued in the name of HHLL. That's one of the new codes, but then she sends an email, so that was the new codes that were being set up under the or set up in relation to the SHA, and then she sends an email to Mr. Hughes, when should we port everything over to Medical Supplies Direct? So they had arrangements to be made for customers to be invoiced by their new company, Medical Supplies Direct Limited, rather than by either Hughes Group or the SHA company, which was HHLL.
Can I understand, for example, in relation to PFW, it says at paragraph 415, had previously placed orders but not a particularly loyal customer. You resting your case on Acorn being the business connection, or on something to do with PFW?
Well, in relation to all of these UK customers, plainly not just Acorn with respect, and the judge, again, just to remind you how he actually decides it, look at page 172, paragraph 424. In reaching a conclusion on section 29, Mr. Justice Richards says, second line, obliged to account for the following benefits. And so he then runs it all together.
Well, that doesn't read to me as saying, I'm just trying to understand what your case is. Are you saying that PFW labels is a business connection?
Yes, the judge finds in terms it was a previous customer of the partnership. I mean, at some point we're going to talk.
This not, so any customer is a business connection, is it?
Do I have to say any customer? I mean, in general, customers are, by definition, one would have thought, within the business connection of a partnership.
If I have a customer that equally shops around, not particularly loyal, under section 29, your case is that you automatically have to account for the profit.
Well,
maybe we need to get onto that, obviously, but just trying to understand.
I don't think I need to go to that point. I mean, although I would, with great respect, say that if you have somebody who has bought from you, then prima facie, unless one can say this is a purely transitory relationship, it's me passing a shop on the street and I'm thirsty and I go in and I buy a bottle of water, I'm not a business connection. But if it's a shop round the corner, there are 3 or 4 shops round the corner, I tend to go to all of them, but I do go to all of them, or I go to 1 or 2 more than I go to the others, then I'd certainly say that sort of custom is business connection. And I would suggest that in principle, just to leap ahead a little, business connection should be interpreted as an ordinary piece of English in a statute. It doesn't have a definition. Parliament could have put one in, but didn't. And it means the commercial relationships of the business. And that's just literally what the words mean. They aren't words that don't have a meaning in ordinary English. And the ordinary approach to statutory construction is that when Parliament uses a phrase in ordinary English and doesn't define it, one applies the ordinary meaning of the words. And business connection, a partnership's business connection, which is of course used as an aggregate term, is a way of saying the commercial relationships of that concern.
But as I understand it, you just say the partnership bought lateral flow tests from Acon. Judge found Acon was a business connection. Therefore, in the future, any purchase of Acon lateral flow tests by Mr. Hughes would fall within Section 29. It doesn't matter who he sells it to. As I understand it, that is the consequence of the judge's judgment, isn't it?
With one rather important qualification, I think, which is to what extent does the transaction derive from the connection that the partnership has? So at some point in time...
Connection with who? I thought the judge's logic is that the connection, as long as it's an Acon test manufactured by Acon, Acon is a business connection, ergo any purchase of an Acon test is falls within Section 29. Have I missed something?
Yes, because with the qualification that I was just referring to, that if you spun it out many years into the future, my lord, at some point one would say this is no longer derived from the partnership's business connection.
Why? It's still Acon tests.
Because there's been...
Where does the judge say there's a time limit on any of this?
I'm sorry?
Does the judge say there's a time limit or spell out?
No, because it's not relevant to the facts that he was considering. And it's a trial to issue, isn't it? That's the whole point. That's why the judge orders to the extent derived. But what we were looking at in this judgment was orders placed within a few months of the partnership ceasing to exist. And yes, if Acon is a distributor, if Acon is a manufacturer supplier that is selective about whom it uses, as the judge found, as is not challenged, then it is a business connection. And if you make a sale, then prima facie that is deriving a benefit from the business connection that you have obtained by being a partner. And we can see Mr. Hughes doing precisely that, lining that up on the 15th of June when he starts his communications with Acon. And if I can go to paragraph 171, the judge sets it out again in a critical set of conclusions that's not appealed, not challenged. He accepts the claimant's case advanced in closing.
Sorry, where are you?
171, 420, my lady.
Sorry.
Not at all. The partnership's business consisted of purchasing tests from Acon and selling them to profit. Acon were selected about who they supplied. Following dissolution, MSDL, company affiliated with Mr. Hughes, purchased LFTs from Acon and sold them at a profit, and the paradigm example of that is the Danish deal. So the judge is finding in terms, this is making use of a business connection. And we say...
Sorry, the reason I got into this was because I understood that subject to the timing point you alluded to, it doesn't actually matter who you sell the Acon test to. It's sufficient for Section 29 purposes that they were purchased from Acon.
Yes, and with the qualification that at some point in time, might be the case.
Subject to the time qualification.
Yes.
Who you sell a test to, who you sell the Acon tests, as far on the judge's analysis, is irrelevant.
It's irrelevant to that strand of reasoning, my lord, but it could also be a separate reason why there is liability under Section 29 if, for example, the sale is made by use of the Hughes healthcare brand. As the judge found in terms, that brand was used to sell to other customers. So that is a different form of liability or a different condition of liability under Section 29, but still liability, because there you're using the partnership's name.
Sure. But you wouldn't need to, I mean, you're right, that may be an independent ground for some sales, but you wouldn't need to, because as I understand it, any sale, the judge's logic is subject to the timing, the expiry of time question. Any test bought from Acon, whether unbranded, branded, doesn't matter. because there was a business connection with the partnership with Acorn, that's enough to trigger section 29.
Yes, and
That's fine, I just-
it does, and when considering the extent of the account under section 29, then as the judge made clear, you're looking at and there'll be no doubt much scope for argument about this. You're going to look at the extent to which the benefit did derive from that partnership resource, if I can put it in that way, as opposed to new factors that came in. So
And
that's
just possibly to be pejorative, is your case, is it, that a business in which Mr. Manduka had a substantial interest was nonetheless entitled to sell to as many people as it liked, wherever they came from, in parallel with this?
you're referring to Newfoundland.
Yes.
There could have been potentially a claim against Mr. Manduka that he was also liable to account in the same way, and Mr. Manduka did in fact offer, as the judge records, to account precisely in regard to sales to Collinsons and Radisson.
But he didn't offer, did he, to account for all that he got out of Newfoundland on an ongoing basis for the future?
I'm sorry, my lord.
He didn't offer to account for all that he was receiving from Newfoundland on an ongoing basis.
No, he didn't. There was an attempt, which the judge refers to, at the end of or during the trial, to bring in a claim by Mr. Hughes on precisely that basis, to make a general claim for Mr. Manduka's post-dissolution activities. I see my lord nodding, so maybe I needn't take you to it. And the judge rejected that on the basis that it hadn't been pleaded, and he didn't want to allow the amendment, and that was a decision that's not been challenged. So this isn't a case of the judgment imposing some sort of asymmetrical liability. It's a case where, for whatever reason, possibly tactical ones, Mr. Hughes, who was making all sorts of denials about any liability for post-dissolution activities, perhaps didn't want to upset the purity of that perspective by making a claim against Mr. Manduka. At the 11th hour, he sought to introduce just such a claim, but by then it was too late.
Yeah.
Now,
I think we heard submissions yesterday that there was a misunderstanding in relation to that, what was being said.
That's the it's page 180. Forward-looking claim regarding post-dissolution sales of LFTs. 467, on day 2, the judge asked the parties to confirm the extent, and then the agreed position that he thought was recorded was that Mr. Hughes' pleaded forward-looking claim consisted of post-dissolution sales to the 18 diverted leads, Neurosed's registration of the trademark, and asserted approval of Hughes, Veritas and Cayman. But then the next day, Ms. Rogers sent a further email which was intended to expand it, and the judge rejected that at 469. Although the claimants accepted that Mr. Manduka must account for benefits received from post-dissolution sales to Collinsons, they argue that the relevant paragraph doesn't plead any sufficiently particularised forward-looking claim. The judge agreed, and he said, at the end, the paragraph contains a limited allegation relating to Collinsons rather than any general particularised assertion as to what Mr. Manduka impermissibly did following dissolution of the partnership. So there was an attempt to impose reciprocal liability, but procedurally it came too late. And that's no longer an issue.
Yeah.
But I'm not asserting that Mr. Manduka could have done what he liked without giving an account. Much of the dispute, in reality, underneath the interesting legal points, is framed by that tactical manoeuvring, as it were. Perhaps if the Section 29 claim had cut both ways, we wouldn't have been taking up the court's attention for the last 2.5 days, but here we are. And we appreciate the court's attention and patience. Now, one final point that I should have mentioned in relation to the dissolution, we see at page 127, please. The heading of that page, the aftermath of dissolution, the war, quote unquote, and Mr. Hughes's attempts to secure the ACON relationship. So just pausing there, I mean, the judge did not insert in his judgment what you sometimes find in contracts, that the headings are to be disregarded for the purpose of interpreting my judgment. He obviously thought, as we can see developed, that there was an ACON relationship. That by definition is the relationship with the partnership, couldn't have been anyone else before then, and Mr. Hughes attempted to, and indeed did, secure it. Again, we say that's just consistent only with there being, with that relationship being part of the partnership's business connection. That's what the judge found. I've shown you already reference to connection, contacts, forgive me, in the middle of June. You can see that 218 reference to the better relationship that Mr. Hughes had with Ms. Shui of ACON, where in reference to the potential dispute over the legal aspect of exclusivity, personal element because she liked Mr. Hughes much more. Mr. Hughes, obviously, he's only ever been in touch with Ms. Shui because of the partnership business. I mean, it's a common feature in all sorts of cases where directors leave or employees leave. People often say, oh, well, the customer wanted to carry on dealing with me because we were friendly, and that happens all the time. It's part of a business relationship that you may try and make yourself affable. What was the phrase? Affable, affordable, and available, I think, was what we were told when we came to the bar. That's how you should be. So there was all of that is part of the normal stuff of business relations, and one sees that in the last sentence, Mr. Hughes leveraged that warm personal relationship to seek to persuade Anita Shui that because, as he said, he owned the Hughes Healthcare brand, ACON should not supply either Newfoundland nor the Mandukas with branded LFTs. So Mr. Hughes, not just trying to get it for himself, but to exclude the Mandukas from getting branded LFTs. So having had the Hughes Healthcare partnership asset, he wants to take all of that for himself. And you can see at 219, Ms. Shui is positively helpful to those discussions, to Mr. Hughes in those discussions. And she says, why don't you send me a letter, a collusive letter, etc. And then, so that is then sent, and then on the basis of that, Hughes Group Limited purports to grant a license to use Hughes Healthcare trademark, so directly expropriating partnership property. And then Ms. Shui on the 26th of July sends an email saying we won't sell branded tests to anyone without your authorization, and the judge finds at 220, at least for a period, ACON would not supply either Newfoundland or Mr. Manduka with branded LFTs. Newfoundland continued to be able to order unbranded tests. Doesn't find whether Mr. Manduka continued to order unbranded tests. And then over the page, judge repeats that Mr. Manduka could not obtain branded LFTs from ACON. He persuaded them to, as Collins and Radisson, to buy unbranded LFTs. The judge infers that that was done by purchasing from Newfoundland. So what Mr. Hughes did then was to secure the relationship for himself, to cut Mr. Manduka and his associates, family, out of it. And that then leads to the general conclusion, page 171, paragraph 420. The seamless continuation of the business, numerous facets to it, but the first one, the partnership's business consisted of buying from Acon, who was selective about whom they supplied, and Mr. Hughes, through his company, carries on with that. The last factor, little 5, is branded LFTs bearing the distinctive logo and the partnership's name, Challenger's trading name. Little 3, using the same material. So, for example, I'm reading now from the middle of little 3, when Mr. Hughes wished to stress to Durbin and Unifar, 2 potential customers of MSDL following dissolution, that he had a close relationship with Acon, he sent a copy of the letter of confirmation referred to in paragraph 125 that the partnership retained for Acon. Similar vein, sending clinical studies reports and also making sales over the website at little 4. So the argument that the judge then goes on to deal with is that, well, how can we be carrying on the business if Mr. Manduka is carrying on the business? The judge rejected that argument. It was incorrect in 2 ways. And first of all, Mr. Manduka wasn't actually in the same order of business at all. It was Mr. Hughes who'd managed to basically take the business, take the key relationship, take the brand, etc.
Well, the key relationship with Acon.
Yes, key relationship with Acon, yes.
In terms of client-facing relationships, I don't think we've got much information about the clients of the partnership at the point of dissolution. We know about Collinson's and Radisson, but they seem to go with Mr. Manduka.
Yes, well, we've got various extracts. So, for example, we saw that PFW Labels was a previous customer of the partnership.
Yes, we looked at that. So,
Yes.
So that is the list that we have, as far as I understand it, the list with Boots and PFW.
I'm going to be given a reference. Sorry? 236 at page 130, thank you.
236.
So Collinson's, and Collinson's is important because it's connected with the airline industry. So 236, Mr. Hughes asserted that the only client was Collinson's. The judge finds that that was an overstatement, and he gives a single counterexample, which is PFW Labels, but he says there were other customers as well.
Yes, Radisson is referred to in 221.
Yes. Well, the way the judge dealt with it was in broad terms to say, yes, there were other customers. I'm not going to find all of who they were because that's a trial 2 issue. But those were connections, people who were solicited by using the name, as I've already indicated, also fall within section 29 by definition, because the name is one of the items in the section 29 list. So we now come to, if I may, look at turning to the legal aspects of the case. The starting point of the appellant's case is that section 29 is to be read as follows, and I'm taking this from what Miss Hilliard said on day one after lunch. My Lord Justice Newey may recall that he said,
Tried to slow
this
her
sounds
down.
important, I'm going to take a note of it. He was right with respect that the formulation in argument, as slightly adapted after a bit of discussion with my Lord Justice Snowden, was this: the partner is obliged to account for post-dissolution benefits or profit derived by him from use by him during the subsistence of the partnership property, name or business connection. So that was the way in which I understood Ms. Hilliard to say that the section should be interpreted. And the obvious response to that, it starts at page 103 of the transcript, if my lords and my lady have that. I don't know if you've been given transcript.
Actually, I've had it electronically, but I haven't got it.
No, I'm just giving it to you for your note if
Yes.
it's of any use at all. It's
Yes,
day
please.
one, page 103, line 17. Lord Justice Newey, sorry, this sounds important.
Yes.
Which is how I remembered it. And then my learned friend gave her formulation, and then my Lord Justice Snowden repeated it back, and at page 105 to 106, during that exchange, Miss Hilliard said you could say from use by him during the subsistence of the partnership. My Lord Justice Snowden said that was going to be my question. We're always talking here about post-dissolution benefits, and he put to Miss Hilliard, you accept that if you, during the subsistence of the partnership, use partnership property, name and business connection, the fact that you don't receive the benefit after doesn't matter. She accepted that. And then my Lord asked, if you have something which is identifiably partnership property, name or business connection, but you don't use it until after the dissolution to make benefits, do you have to account for that? Yes, you do. And then the cross-examination continued. Does it matter, in fact, when you use it? You're just saying it doesn't matter when you use it. The critical question is it partnership property? Timing doesn't matter. It doesn't matter when you receive the benefits, and it doesn't matter when you use it. Ultimately, Ms. Hilliard accepted that. At page 107, my Lord put to her, can you use a business connection of the partnership after dissolution without having to account for it? And the answer, if it's a business connection, said Ms. Hilliard, obviously you would have to account for it, yes. So the point was reached. The critical question is, what is a business connection partnership? Yes. So now, we respectfully rely on that, in that, putting it another way, the formulation that my learned friend ended up with, that you have to account for benefit derived from use during the subsistence of the partnership, is an obvious addition to the wording of section 29. It simply isn't what section 29 says. So section 29...
So which bit is an addition?
During the subsistence, the use during the subsistence of the partnership. Yeah, and that was the phrase which got moved around
So
into...
you take that out?
Yeah.
So where do you put a time limit on it?
There's no precise time limit. The court has
No
defined
so
it.
there is no time limit?
No, I said there's no precise time limit, my lord.
Where do you get a time limit from then?
When the factor, when the asset is no longer being used and a benefit is no longer being derived from it,
But on your point, but on the judge, I'll go back to the questions I put to you about 10 minutes ago. On the judge's reasoning, he says ACON is a business connection of the partnership. He says that would be sufficient.
Yeah.
So when do you stop having to account for the
winding up, my
partnership?
lord.
Why?
Winding up.
Why?
because these are all duties that apply in the twilight period. And once there's winding up, it's a final
What
settlement.
does
of
winding
accounts.
up mean in this context?
Winding up means when there is either an agreed or court-ordered winding up, that the partnership accounts are finally settled.
But if you
So
have
that would be-
somebody who is still using a business connection of the partnership and has a liability account under Section 29, why would you wind up, say the affairs are completely wind up? You just carry on.
because you could capitalise it at that point. That would be part of the winding up. So then there's a settled account.
Why should you want it wound up? I mean, on this basis, the other partner is conducting a
Well, there might be
good business, and you just say, you carry on, mate, and just have to account under Section 29.
Well, my lord, your lordship's putting it to me with respect, as if that was some sort of impossible outcome. I don't accept that, depending on the
I'm putting
circumstances.
to you that on the logic, as I understand it, of either your or the judge's conclusion, it would mean that there would never be an incentive for the partner in this situation to bring in. I mean, why would you conclude the winding up? Because you'd say there is still a liability to account for my erstwhile partner because he's still buying a contest.
Because at some point the causative effect is going to run out.
So why? It's the same business connection. It's ACOL. What causative effect? The only relevant causative effect, as I understand it, that the judge put in place and that you say is necessary, is that these are a contest.
Lord, at some point, it's going to be possible to say that the transactions that are occurring are the result of events that have occurred since the dissolution, and therefore they don't represent assets of the partnership. It's just a factual test.
It doesn't have to be an asset of the partnership on your or the judge's interpretation. It just has to be a quote business connection.
Well, I'm sorry, I'm using the term assets as a shorthand for all of the items, just a convenient label.
Right. So do you accept that the business connection is limited to the connection which represents an asset of the partnership?
No, I'm putting it the other way round. I'm saying that, with great respect, my lord, no, I'm not saying that. I'm saying something different. Section 29 is designed to make a partner account for the benefit that he's derived from things which could be called assets or advantages of the partnership. That is the general intention behind Section 29. And the list of items, the short list, property, name, the business connection, in each case of the partnership, is intended in my submission to be a general and comprehensive list of the items, of the advantages and assets in the broadest sense that somebody may get from their association with a partnership involving their partner.
May I ask a slightly different question? Given that Section 29 requires accounting to the partnership, wouldn't winding up be impossible, and on your case, until that imprecise point of time has actually arrived?
With great respect, my lady, no. I mean, the court can decide when winding up is appropriate. As I said earlier, if it,
Winding up by definition requires final accounts, doesn't it? How do you do that if there's an ongoing obligation to account?
it creates a final account. That is the outcome of the winding up. So if you need to capitalise what might otherwise be an ongoing income stream from one partner's use of an asset, using that as shorthand, not as a trap for the partnership, for the list in Section 29, then that can be done as part of the winding up.
So so in a situation where two people in partnership, one of them continues to conduct business buying something from a manufacturer who's been said to be a business connection, they just are carrying on. I mean, it is the point my lady was putting to you, and it's the same point I was putting it less elegantly, if I may say, but it's the same point. Why do you say the court would be prepared to grant a winding up order when there is continuing business? Or do you say, well, what the court has to do is to what? Capitalise the future and indefinite income stream of that partner?
So in many cases, what will happen is it will be apparent that the benefit for the responding partner let's say, just, and I'm not trying to pin myself down, but just to make it easier to give you, to illustrate what I have in mind. Let's say 2 or 3 years later, there's been business carried on by the departing partner who's been asked to account. He's carried on business. At some point, it would often be possible to say the transactions that are now occurring are derived from that intervening course of business. And that's what's really driving it, rather than what happened during the partnership.
But I don't understand where you introduce the concept of causation into this whole analysis under section 29, because if the judge is right, causation is irrelevant. It's simply the fact of buying tests from the same manufacturer that the partner produced.
I'm deriving it from the word derived. Benefit derived. I suggest that's a word that imports causation in section 29. It's conveniently set out at page 131 of the bundle in the judgment, which has all of the key sections in one place.
Just to be clear on one point, which I think you are saying, while obviously you contend that obligations continue post dissolution, you do accept there's a cut-off at dissolution. So that
cut off at dissolution, did you say, or
at dissolution, post dissolution, the extent. Well, tell me if I'm wrong. Post dissolution, the section 29 obligations continue in accordance with section 38.
No, the starting point is that the obligations under section 29 apply both before and after dissolution.
Yes, are they coloured at all by section 38?
Well, subject to section 29.
So just
Section 38, the judge. Sorry, my lord, I don't.
no, sorry, go on.
Well, I was going to say the judge accepted our submission, page 137, paragraph 263. Section 29, section 38 are directed at different matters. 29 provides the partners to account, and section 38 clarifies the scope of partners' authority to bind the firm in the so-called twilight period.
So can I just try to fit into this the bit of Lindy I mentioned yesterday morning? Lindy says, or you may say Lindy's wrong, that post-dissolution, anybody, either partner, any partner, can use the name if there's no goodwill. Now, do you accept that or not?
I'm going to have to think about that,
Yes.
because I haven't, I'm afraid, in the course of preparing overnight, had a chance to think about that.
I mean, you would certainly say, would you, well, you better say, as you say, you need a chance to think about it. You would certainly say that pre-dissolution, it'd be quite wrong for a partner to use the partnership name for himself.
Yes.
So if Lindy is right, we need to fit into the scheme the fact that post-dissolution, the position is different.
Well, it may be that there's an implicit factual assumption underlying the statement put forward as if it were a legal proposition in Lindsley, that if there is no goodwill, then you're not actually deriving a benefit from the name. I can see that that might very often be so. As I was saying in debate with my Lord Justice Snowden, I do assert that the word derived or derived from, that verbal phrase in the middle of section 29, subsection 1, has a causal connotation. In Lord Briggs's phrase in Recovery Partners, he refers to it as protean causation because he says it's to be distinguished from common law causation where you have a but-for counterfactual, but he, Lord Briggs, is very keen to tell us all that there is a causal requirement, and I'm afraid be taking you to the judgments in Recovery fairly shortly.
And just pursuing it a moment longer, so suppose that were the explanation. If there were no goodwill attaching to what we'll call a connection, then that would fall out of account too.
count two being what, sorry? I'm trying-
Well, if you can use your name post dissolution, provided there's no goodwill attached to it, would it also be the case you can use a connection if there's no goodwill attached to it?
That I wouldn't accept. The argument I was canvassing without having had the chance to reflect fully on it is that one might explain Linley and Banks's comment by reference to a factual, plausible but not absolutely necessary factual assumption. I'm just trying to square.
Yes. I know
certain
you
comments
said that you
in-
would
in
like time to think
textbooks.
about it.
What I do say is that the task for the judge, as with any judge applying a statute, is, as Lord Herschel said in the Vagliano brothers case that we looked at on day one, is you start with the ordinary meaning of the words in the statute. I mean, that's just axiomatic. And if you do that, then just treating it as a kind of instruction to the court, you ask yourself, has there been a benefit derived from any use by a partner of the partnership, property, name or business connection? I mean, that's the factual question which is posed to the court. And the answer is, if the answer is yes, then every partner must account to the firm to it. So the court is obliged then to grant the account. Now, the extent of the benefit derived is another matter. Obviously, that's part and parcel of what has to be investigated. But on the face of it, this creates a simple and straightforward piece of law, which is to require that accounting to take place when the specified circumstances are met. So the first question is, when considering the appellant's submissions, is there any basis for reading words into the statute? Because if you say, as I suggest she has to say, and as she did tell you, that it's post-dissolution benefits derived by him from use of partnership during the subsistence of the partnership, property, name or business connection, then that is, first of all, she wasn't able, as I understood the dialogue with my Lord Justice Snowden, to sustain that proposition, because she accepted that, in fact, what counted was whether you had been making use of one of the items, I'll call them for shorthand assets, not wanting to dig a trap for myself in section 29. She accepted that it didn't matter when the transaction started. And that, with great respect, we rather like that bit of the hearing. We thought that my Lord's logic was, with respect, irrefutable. And looked at another way, words are being added in on Ms. Hilliard's interpretation. So what's the basis on which that exercise of statutory construction is being propounded to the court? The only basis that we can see is there's no authority in whatever it is, 135 years of the Partnership Act 1890, no authority that says this, nothing to indicate it. As we understand it, what's said is you have to look at section 46.
Is there any authority in the last how many years, 130 years, really turning on business connection?
Not that.
Except on Taylor's, which was
Yes, well, I mean, Mr. Crossley doesn't have anything either. I've not seen anything. As a matter of fact, in the case of Ass against Benham, which was decided just after the Act came in by reference to facts, just before the Act came in, Lord Justice Linley, as he was, uses exactly the same phrase. I see my Lord. So,
the Act was in, I did check that, the Act was enforced by that.
yes, the Act was
It's
in.
only referred to in one of the other I think one of the other judgments refers to section 29, doesn't it?
The whether it was a bit of unconscious plagiarism,
Probably.
I wouldn't like to say. He wasn't the drafter of the Act; it was Sir Frederick Pollock.
Yes, but he must have been highly familiar with it.
It would be a remarkable coincidence, my lady, would it not, if he'd come up with the self-same phrase and had never read section 29, despite being of the leading book. all of the facts and what the court was dealing with in Ass against Benham were pre-1890. I
Yes.
think it was 1887 was the date when the
But
shipbuilding.
we also know his view that the Act didn't change the pre-existing law.
I'm sorry, my lady?
His view, his expressed view, was that the Act did not change the pre-existing law. So, again, for that reason, maybe his reference, and he doesn't explain what he means by
No.
business connection.
No,
So we're not really taken further forward.
I was
by
going to
that.
say, it's a bit circular, isn't it? That he states the pre-existing law in terms which, deliberately or not, mirror
Take a
the
step
existing
further.
statute. I think we're safe to say he was on fairly safe ground in the particular proposition that he advanced. But the question, what is meant by this phrase business connection, was not, as far as the researches of all of us on the bench, at least the council's bench, have been able to discover, wasn't the subject of any pre-act learning. I mean, it's a phrase that's used in cases, but just as a description, and it's not the subject of any analysis. And
Is it a singular thing?
well, so I describe it as a collective or aggregate noun, business connection. So what I when it's, if you remove the intervening words just for the sake of it, it's make use of the partnership business connection. And my interpretation of that is that what it means is that the total or any part of the partnership's
Yep.
commercial relationships. So that's when but the business connection is the partnership's commercial relationships. That's what the phrase means. Connection is in effect a slightly old-fashioned word. Well, it is an old-fashioned word for relationship.
I don't know what a dictionary in 1890 would have said connection meant.
It wouldn't be goodwill.
It's related, but it isn't goodwill, and goodwill wasn't an unknown.
It's also not business connections plural, i.e. each and every contact encountered in the course of business by a partnership.
Well, that's why I describe it as a collective. Or
Yes,
aggregate
but then
phrase.
you qualified that quite neatly by slipping in the words or any part.
Yes, because if you use part of the business connection, you're using the
So
business connection.
Is it triggered if you use a single contact forming part of the?
Yes, let's imagine that, take a classic case of some hairdresser who has clients, and they can be very valuable. Such cases in the Mayfair type, a lot of money generated, but there's no long-term contracts. The people who come in and have their haircut they're not customers who have an exclusive contractual relationship, but they have a habit of going to John Frieda or whoever it might be and getting their haircut. And on that basis, if one customer, if Kate Moss goes to have her haircut, she doesn't have a contract, but goodness, if you pinch Kate Moss's business, that's definitely making use of it, and that would fall within section 29, and that's one of many people who go and have their haircut. So it's all part of business connection, and the phrase is used, as I say, as part of I'm picking up on what a hint, I'm not saying it's intended to lean in this direction, that my Lady Justice Falk gave us on day one. You've got to look at the totality of section 29, subsection 1, and say, where's it going as a whole? And I submit that this phrase, short though, the total phrase, partnership, property, name, or business connection, is intended to provide a comprehensive summary of the advantages or assets or resources, using it in modern language, that one may derive that are commercially valuable, that may come out of a partnership. And just, if my Lord will just forgive me, it's a duty to account for benefits that you derive. So it's concerned with value that's been extracted by one partner as a result of a connection with a business, and you're looking at things that are commercially valuable. And our cases, just leaving aside customers, although they were customers, and leaving aside the name, although there was a name, the relationship with ACOM was a relationship, it was valuable, and it was the source of income for the partnership. And so it is possible to say, and the judge has found, that benefits were obtained using that relationship, and that falls within the wording of section 29. And that's not our only case, but it is our key part of our case, and it is a sufficient, though not necessary, condition but it is enough on its own to generate liability under Section 29. There was a relationship with Aecon, and that formed part of the collection of total commercial relationships, of business relationships, which this partnership had. And the section precisely ensures that if one partner derives value from those associations, that connection, he should account for it. That's what it's about.
Can I just go back to the sort of point in time? So if the relationship with Aecon is the partner customers starts off being a business connection, you say there comes a point in time when it no longer is. Is that a sort of switch that turns off, or what? Because
Post-dissolution, you mean?
yes, certainly the way it's left by the judge, I think it's for trial 2 to work out, isn't it? What level of business is derived.
Yes.
It's an almost impossible task. I mean, how would you identify when, in your example, you switch from Aecon?
Well, I don't suggest it is necessarily a switch. It's more a fade to black, isn't it? But at some point in a business sense, the court is required, I mean, that's the task that the section imposes, is required to account for it. And take my hairdressing example. You have a celebrated fancy hairdressing salon in Mayfair with lots of celebrity clients, and they aren't linked by any contract, but they go there. And then after the dissolution, one of the partners continues to take the benefit of those customers' custom. But at some point, you would say enough work has been done post-dissolution when the partnership was no longer active in the sense that it was pre-dissolution, to mean that the continuation of the business is due to that subsequent work. And precisely where that line is to be drawn is for the trial judge, after steeping themselves in the facts, to decide. And that's inherent in Section 29. However you look at it, you are, if you're looking at business connection, which must at the very least include the classic case of a repeat customer, I'd say it's not remotely limited, but it must include that. At some point you're going to find that the customer's attachment to the partnership has been superseded by attachment to the new business. But until then, there is benefit being derived. That's, you can't avoid that as an exercise under this section. And it's not, with respect, an unknown exercise in other contexts. I mean, there are cases where in the company context, you have to consider whether or not a particular benefit was obtained as a result, as we can see when we go to recurrent partners, as a result of or by reason of the previous relationship. And inevitably, where there are other factors, you may have an attenuation of that relationship in place of what subsequently happened.
So how does it work when the celebrity goes to the hairdresser continuing to cut hair at the salon previously occupied by 2 hairdressers, and said, well, thank goodness that other bloke's left. I never had it. He only cut my hair once and it was terrible. I'm only interested in having you cutting my hair, and I only ever have done. Is that's an end, is it, of the use of the partnership business connection?
It would all, I mean, it would all depend. I'm sorry, my lord, I can't, it's not appropriate in my submission to construct fixed rules about that. One can see that could be a factor to consider, but you'd also need to consider to what extent the original connection had been formed by use of the partnership, by use of the premises, by use of the overall business, the fact that the a particular hairdresser whom the client liked was able to set up in this swanky location in West One, etc., etc., and it would all be part of a total analysis. You wouldn't necessarily say simply because there's a personal element that the influence of the partnership business, which had generated the relationship in the first place, suddenly came to an end. So it would all depend on the circumstances. There is a case, although it doesn't discuss business connection, which the court may find of some assistance.
Just before you do, while it's in my mind, can I just pursue one thing for a moment? and then we should come back to the case you want to refer to. As you talk, to some degree, one might think there's a choice between understanding business connection very widely and then making sense of the law by focusing on derived, or alternatively, understanding business connection more narrowly from the start. And just to test how you see it, can I take the example of the newsagent partnership, which comes to an end, and they've been buying the Times from the Times, and they've been buying Kit Kats from Nestle. Now, you would say that Nestle and the Times and Times newspapers were within the scope of business connection?
If they've been buying from them, then they do represent a relationship of that business, yes. But
so then you throw the weight on derived.
well, yes, because if it's, I mean, if it's Nestle, then I assume that they will, in practice, sell to anyone who asks, so that there's no question of having any degree of preference over the market generally. In other words, it's not a case of Nestle being selective as Aecon was here. So, in effect, the newsagent is in exactly the same position vis-a-vis Nestle as I am if I go into Tesco. That they will sell to me and Nestle will sell to the newsagent.
So just to understand your case, you would say, well, the post-dissolution partner, so be it Nestle is part of the business connection, but the post-dissolution partner derives no benefit from that connection because they could order from Nestle anyway.
That would, on those bare facts, that would seem to be a likely outcome. One can immediately start imagining sort of permutations, but you know, as with these hypotheticals, it's somehow it may not be the most fruitful way to address the situation. But if you're looking at what I mean, if you're looking at what I submit is the underlying idea behind Section 29, which is what's commercially valuable in the enterprise, in the partnership, and ensuring that what's commercially valuable remains to be distributed between the partners, then there's nothing surprising about saying, look at the commercial relationships that you have, even though they're not property. I mean, of course, the Act could have limited itself to property. We'll come on in a moment to see that that's not a term that's to be taken in a limited way, but it could have been limited to property, it could have been limited to contracts, it could have been limited to customer connection. That would have been a narrower phrase, but none of these phrases use business connection, which is a pretty general phrase and taken with the others, connotes, in my respectful submission, an intention to cast a broad net. I would also make the point the other way around, my lord. What is the interpretation and what is the basis, what is the legal, if you like, conceptual basis for a narrow interpretation? Where do you draw the line and why should you draw it? Whereas my interpretation is just to look at the words, the commercial relationships, the total of the commercial relationships are, and is that, or the collectivity, to use a neologism, is that being used for the benefit of one partner? And when that happens, then that triggers a duty to account. And whether it has happened will be very fact sensitive, and there will be difficult issues that my Lord Justice Snowden's questions have pointed up as to how you draw the line, and that may be a difficult problem, but it's inherent, it's unavoidable. Whatever construction one gives to this phrase business connection, even if you take it in the narrowest sense that I've been talking about with my hairdressing examples, and we could no doubt multiply many others, you're still going to have those kind of questions. I was going to refer.
Yes, I distracted you for a long time, but thank you very much for.
Well, I'm trying to help. And there's a case which doesn't, as far as I can see, use the term business connection, but it does indicate how the previous law operated. I'm going to make some submissions that the previous law isn't something that should be allowed to override the plain words of the statute, but just by way of setting it back. This is tab 9 of the authorities bundle, page 67, and it's a case called Willett against Blanford. It was the decision of Vice Chancellor Wigram in 1841 and 1842. He has two judgments in short order.
Sorry, I must have misread your page number.
67, my lady.
Thank you.
Can we just look at the headnote, as it's quite a long report and quite small print. Where a surviving partner has carried on the partnership business without withdrawing from the concern the capital share of a deceased partner, i.e. capitalisation, there is no absolute rule that in taking the subsequent accounts of the partnership dealings as between the surviving and the estate of the deceased partner, the division of the profits shall be determined by the aliquot shares of the several partners in the business in their joint lifetime, or by the amount of the agreed capital that they were respectively supply, or by the amount of the actual amount of capital belonging to the surviving and the estate of the deceased partner respectively. But the principle of division may be affected by considerations of the source of the profit, the nature of the business, and the other circumstances of the case. There was a partnership between a Mr. Willett, Mr. Vince, and a Mr. Blandford, picture frame makers. Turning over the page, just next to 255, if you can see that in bold type about a quarter of the way down, Vince died, and so then the partnership was, and he drops out of the story. It's then Gerard Willett and William Blandford. And so they carry on the trade, which is a trade we can see a bit further down, of picture frame maker and carver and gilder, just down the road as it happens in Bouverie Street. And Willett, you can see just below 255, is entitled to the extent of 7/10, and Blandford to that of 3/10 of the business. So they had not a 50-50, but a 70-30 partnership. And then just above 256, about halfway down the page, in August 29, Gerard Willett died. So he has a wife, and then dropping down to the next break on the page, after the death of the testator until the expiration of the original partnership term, and then till 1838, William Blandford solely managed and carried on both trades on the premises in Bouverie Street under the firm of Willett and Blandford. So for 9 years, Blandford carries on framing pictures and gilding, etc. Himself. And so then the question arises, what about the account? Conclusion was reached at page 71. This is the first judgment of the Vice Chancellor. About 2/3 of the way down the page, about 8 lines below the number 264, you'll see beginning about 1/3 of the way through the line, there is no ground upon which Mr. Blandford can be relieved from his liability to account unless he can bring himself within the protection of the partnership articles, but those provisions haven't been pursued. So he finds that, for whatever reasons which don't matter, Blandford had to account, he couldn't escape that. Over the page in our bundle, so first break on page 72, 5 lines down, the next question is one of much difficulty. Whether, as the plaintiffs insist, the estate of the testator is to have 7/10 of the profits of one concern, half the profits of the other. There was some side business, because those were the proportions in which he was in his lifetime interested in the partnership. So was Willett's estate entitled to 70% of the profits? And the obviously that was what Willett's estate argued, dropping down to the very bottom of the page, 2 lines up, the question I variously anxiously considered is whether I ought now to adopt any rule or whether I ought not to follow the course which was taken by Lord Eldon and keep my hands unfettered, that I may hereafter do that which justice requires, if the case were one free from difficulty and only requiring a simple application of a uniform rule. Then he refers to some previous cases, which he says were in effect decided on their own facts, and he concludes, I must therefore believe that the circumstances of the trade and property of the partnership require very great consideration before I can finally dispose of this case. But he says he's going to consider it further. He comes back on January the 12th, and he says, beginning about a third of the way down the page in the second paragraph of that judgment, in this state of the, well, I should actually read from a little earlier. He says, I decided that Mr. Blanford, as surviving partner and one of the executors, having after the testator's death carried on the partnership trades without withdrawing therefrom, the testator's property was liable in equity to account to his estate for some proportion of the profits made in each of these trades since the testator's death. I'm not informed at present of the value of the stock in trade or of the amount of capital or of the current profits of either partnership at the time of the testator's death, nor do I know to what extent the successful prosecution of each business may be dependent upon the personal skill and attention of either partner or upon new capital brought into the concern. And in this state of the case, it was strongly urged upon me I ought at once to declare that the testator's estate was entitled to 7/10 of the profits made since the testator's death by Mr. Blanford in the trade of picture frame maker, and moiety, the profits of the other trade. To this it was said the plaintiffs were entitled as a matter of right. My opinion was that the proposition thus contended for could not be maintained in a broad and unqualified manner. And then dropping down, I've again considered the subject. Remain of the opinion I expressed at the close of the argument, there's no rule of this court applicable alike to all cases. There's no rule which is so established or general its applications be taken to be the general rule until circumstances is shown which displace it. In other words, there's not even a presumption. Facts of each case must be fully brought under the view of the court before it can be in a position to state what justice to the parties seeking its protection may require with due regard to the interest of the other parties. And then he gives, starting at the last break on this page, a series of generalised examples. The circumstances of some case would almost exclude the possibility of making a decree in any other form than that which the plaintiffs claim in this case, i.e. the 70-30 division according to the capital. Take, for example, the case suggested by Lord Eldon in Crawshay and Collins, the mere conversion into money at a large profit long after the testator's death of the very property which belonged to the partnership at his death, no other circumstance to embarrass the question. Again, the dissolution of the partnership prima facie prevents new contracts being made on the joint account of the partners, but it necessarily leaves the old contracts of the partnership to be wound up. In the absence of circumstances to alter the case, it would be impossible to deny the right of the estate of a deceased partner to participate in the profits arising from winding up the old concerns. And if in such a case the surviving partners should have so mixed up new dealings with the old that the two could not be separated, the right of the estate of the deceased partner to share in the profits of the new dealings might unavoidably attach. In another case, a partnership may be formed, the substratum of which may consist of specific things of peculiar value in their use, as, for example, patents, the inventional property of one of the partners, and the profits made after the death of the patentee or owner of the patent may be derived wholly or principally from contracts subsisting at his death, but not wound up until long afterwards, or contracts entered into after his death, of which contracts his specific property, the patents, may have been the medium. I understand that to mean the means. In such a case, and in the absence of special circumstances, it would be difficult to suggest a principle upon which the estate of the deceased partner should be refused the same proportion of the profits which he enjoyed in his lifetime. And dropping down again, the whole of the substantial part of the trade may consist in goodwill, leading to renewals of contracts with old connections. One sees the word connections. In such a case, it is the identical source of profit which operates both before and after dissolution. Circumstances may be suggested of a very different kind. Take the case of a business in which profit is made by the personal activity and attention with which the use of the money capital is directed. The case may require a different determination. Or there may be the case of two persons being partners together in equal shares, one finding capital alone, the other finding skill alone. Suppose the latter, before his skill had established a connection or goodwill for the concern, should die, and the survivor, by the assistance of other agents, should carry on the concern upon the partnership premises. It could scarcely be contended after a lapse of years that the estate of the deceased partner was entitled, as of course, to a moiety of the profits made during that lapse of time after his death. In other words, the derived from has started to run out. And if his estate would not be so entitled where the deceased partner had left no capital, it would be difficult to establish a right to moiety only, because he had some small share of the capital and stock in trade engaged in the business of his death without reference to its amount. Other circumstances of the case, if on the other hand, the skill of an individual without capital had been exercised as a partner in a concern until it had created a connection and goodwill, and upon his death his surviving partner, instead of giving to the estate of the deceased the benefit of that goodwill by a sale of the concern, should think proper to carry on the concern for his own benefit until the connection and goodwill were lost. It would not be difficult to justify a decree which in such a case should declare the estate of the deceased entitled to share any profits made after his death. If capital were to be taken as the basis upon which in every case partnership profits, proportionate profits was to be taken, was calculated, much injustice would often ensue. In partnership cases, the agreed capital of a concern, considered in general as remaining the same, notwithstanding advances. If at the death of an acting partner, he'd abstracted or borrowed money, it would be anything but justice to hold as a rule of course that his rights should continue, etc. And then at the bottom of the page, last break, I consider myself therefore bound by authority and reason to hold that the nature of the trade, the manner of carrying it on, the capital employed, the state of the account between the partnership, the deceased partner at the time of his death, and the conduct of his parties after his death may materially affect the rights of the parties, and therefore I need more information. And so the decree that's made on the next page, ordering the master, 5 lines down, it is ordered that the master do take an account of the partnership dealings and transactions between the said testator, Gerard Willett, and the defendant, William Blanford. And then it's up to the death, but also after the death. And then if we go down to about 8 lines above the number 274, or rather we can start just 1 line above that, and it is ordered at 274 the said master be at liberty at the request of any
Sorry,
person.
I've
Just around.
Yes, I've got that.
Oh
yes.
yeah, thank you. Ordered the said master be at liberty to state such special circumstances as to him should seem material as to the nature of each or either of the said businesses and the manner of carrying on the same, as well in the lifetime of Gerard Willett since his death, for the purpose of showing how far each or either of the said businesses may have depended on the personal skill of Willard and Blanford, or either of them. So and so on. So the answer is that, you know, in less beautiful English, one would say it's a multifactorial assessment. You've got to look at all the circumstances of the business. You've got to look at the nature of the trade, at the degree of to which personal skill may have contributed, etc. And that, we say, is something which is very akin, if we look, for example, at the Danish deal, to the exercise that the judge went through in some detail in paragraph, I think it was 364, etc., where he talks about 394, sorry, where he talks about the different factors.
What that authority points up is, or what it seems to suggest is, it's the use of partnership property without giving the exiting partner a return of their capital following a sale of all the partnership business and assets. And that's what was said a number of times. It's the problem Section 29 is designed to address. It sort of dovetails with your answer to me a little earlier that on-time limit is the completion of the winding up of the affairs of the partnership, which will involve a realisation of all assets. Yeah. So, in our current case, if there was a sale of the partnership assets, what would you be selling in relation to ACON,
Well,
if anything?
what would you be selling? You'd be at the time of dissolution, you mean?
Yeah, I mean, just following the logic of this case, which you've taken us to, which sort of you're saying this is some sort of analogy or underpinning what Section 29 is driving at. At least I think that's why you were showing us it.
Yes, I was saying that the concept of seeing what benefit has been derived.
But the quid pro quo, or the whole ethos of this is you can't carry on a business without paying the other partner out following dissolution.
Yes,
and I'm saying, well, and I'm trying to identify at the moment what asset or what you would be selling in relation to our partnership if you attempt to monetize the relationship with Acorn.
But you
Could you?
You don't have to put it in, frame it under Section 29 or under the law as it would have been at the time of Willett. You don't have to frame it in terms of what you would have been able to sell it for, although you might use expert evidence if you were trying to approach it on that basis.
What would it be?
Well, yes, no, I'm
Sorry.
coming to that. So you would be able to sell in this case as something tangible to which you could then attach other things. You could attach the you'd be able to sell the name. So the Hughes Healthcare, that's a brand, and that's a trading name, and you could sell that. Indeed, one could see there was argument over who owned it and who was entitled to it. You could sell the right to use the name in relation to those tests.
So I was focusing.
I'm just building up from that. Sorry. So
I'll let you take your run up. Sorry.
No, I'm just. You could then attach to that, positively or negatively, as I will explain in a moment. You could say that goes with goodwill, including the connection with Acorn, and you would reinforce that. And there are many cases, one or two, which I'm going to take you to in the Victorian Edwardian era, where partnerships were sold, and this question of how you preserve the connection of the partnership came up. And it was done by covenants and by an implied non-derogation from grant, so that you would then sell with the protection of keeping the old partner, the vendor, away from the business that you created and away from the connections of that business. So in a typical case, leaving aside the supplier, which is a slightly refined example, but correctly accepted by Ms. Hilliard, you can have even goodwill with a supplier. If you take the ordinary case, the hairdresser type of case or whatever it is, Willett and Blandford's, whichever nobleman sent their pictures to be framed, etc., the key customers, if that business were sold, then you would sell the premises and the name, and you would then sell and the stock in trade, and you would then get, both by an implied covenant not to derogate from grant, and if you wanted to, by express covenants, exclusion of the vendor from the field of business, and at a minimum from contact with the connection of the business. So you'd be prevented from soliciting the customers of the former business. And in that way, you would be able to monetize the connection.
Okay, so can we? I follow the logic of that. I just wonder whether it's a law. So you have two individuals carrying on a newsagent business together. They fall out. The partnership's dissolved. You say neither of them can carry on business as a newsagent in future.
No, I say each of them must account.
Well, I think, did you not say that you'd provide for the exclusion from the field of business?
Well, that's if I was talking about where there's a sale of. I was in response to my Lord of Justice.
Sorry, then. Ordinary partnership law says when there's a dissolution, if it's a real dissolution, not a technical dissolution, you realise the assets. And I think it's somewhere in the bundles you've got Cobden and Cobden, which sort of talks about all this. And so you would sell goodwill. And the sale of goodwill would mean that neither of them could then carry on business as a news agent?
If it's purely the sale of goodwill, then under the law as it got to in a case called Trigo and Hunt, which we handed up yesterday in 1896, there is as I read that case, there is a general proposition that there is an implied covenant imposed on the vendor of a business that he will not derogate from his grant, and that will include not soliciting the customers of the business. If I recollect correctly, so in other words, not soliciting the business connection, to use a non-coincidental phrase. I will check, but I don't believe it goes as far as saying that you're actually prevented from competing in the sense of operating in the same field of economic activity. So it's not like an implied non-compete, restrictive covenant, but it is an implied non-solicitation covenant in effect.
And so you're obviously going to take us to this case in due course, but so each partner could set up in the area, provided and sell to the same customers if they happen to come through the door.
At that point, I think rather than go
Yes.
by my not completely photographic memory of a 100-page law authority, I'm going to show it to my lord. Perhaps we can get there in due course. Can I just come back to where I had got to a little while ago, which was just the how we understand the appellants to put their case for saying that you do add, and we say it is their case that you should add into the wording of section 29 some further concepts, and that's been put in one or both of two ways, that the using the phrase use during the subsistence of the partnership. So that phrase, which was at pages 103 to 109 of day one transcript, resulting in discussion between Miss Hilliard and my Lord Justice Snowden, and an acceptance that even if transactions start after dissolution, there's still accountability if you fall within section 29. And another way in which they put their case, which is what the judge was faced with, was the argument that there has to be an independent breach of fiduciary duty. Now, I don't believe from what I've seen that has ever been precisely formulated in the sense in which one often expects in a statutory construction argument, where somebody says, these are the words which are to be read into the statute. The argument seems to be put on a somewhat broader basis that despite the wording, or notwithstanding the wording of the statute, there's a requirement for there to be an independent breach of fiduciary duty separate from the failure to account for the profits made within the bare terms of section 29.
I mean, a variant, which I'm sure you'll come to, is that in understanding what section 29 means, you say, well, it's intended to mean the sorts of things that are encompassed elsewhere by fiduciary duties.
Yes, and we say our interpretation is perfectly consistent with that, but in any case, you still have to find some words, even if it's not correct, and I say it is the case that section 29 in effect codifies or embodies in its particular way the concept of a fiduciary accountability for use of assets in the broader sense, things within the scope of the fiduciary relationship. Even if that's not right, you still have to, as a matter of statutory construction, you've got to say what are the words that are to be read into the statute.
Alternatively, again, and I know you'll come to this, it's a matter of construing the word connection. Does connection mean what you have just been explaining you say it means, or does it have some narrower meaning
Yes,
to do with something where there's goodwill or a maturing business opportunity or something along those lines.
That's a different mechanism from the independent breach of fiduciary duty, as I understand it. It's a very different approach.
It's a different approach. It may come to the same thing.
May come to
in
the
the
same
sense that if you say, well, really we think this is intended to cover the same ground, then you would expect it to catch some things and not other things.
First point, if that is the case, then I think your lordships and my ladyship could reasonably expect to have some precise verbal formulation which would actually replace the words or conclusively define the words used by Parliament. So if there is to be a particular meaning given to the phrase business connection, which is narrower than one might otherwise take it to be, you've got to say, well, what is that meaning? And I sat here for 2 days and didn't hear any such meaning, nor is that the case. I've heard a number of suggestions of a kind of looser sort. So, for example, Ms. Hilliard said, well, there wasn't exclusivity. But if her proposition is that there is business connection only if there is exclusivity, then we say that's wrong. We say that is a plain graft onto the words of the statute, and it will also lead to the most remarkable results, because there are legions of businesses, as in my Mayfair hairdress, for example, where people are obviously within the scope of what would be protected and they don't have exclusivity, whether legal.
Ms. Hilliard certainly did say that it should be in the nature of an asset belonging to the partnership.
Yes, she did. Well, but I mean, if that is the
At some point,
closest one can get to a definition, I submit that there are a number of ways in which that is not satisfactory. Although even if it were to be taken as a definition, I would also submit that this case falls within it. But let's just take those points one by one. So there's obviously some connection, some association between the partnership and each of the 3 items which are then mentioned in section 29, property, name, business connection. So, you know, it is the property of the partnership, it is the partnership name, it is the partnership business connection. So there has to be some form of association between the two. But to generalise from that to say, well, this must be something which can be regarded as belonging, runs the risk that you elide everything into the concept of property. Because if we are to take belonging as its normal...
Except pre-1890, that was the concept that was deployed when you had dissolution of the partnership, because you then sold the partnership assets and property and you paid out the partners. And as we just saw from your authority, it's when you didn't do that that there was an obligation to account for the use you'd made of those.
Well, but even...
Can I just interject at this point as well, one thing that's going through my mind, which is we talked about various alternatives. Just I don't want to make things worse, but a further one is that there's a whole section of the Partnership Act dealing with dissolution, and we've touched on this before, but one of the difficulties seems to be how Section 29, how you apply Section 29 in a dissolution context, where there are other provisions of the Act that maybe don't appear to result in the same consequences. So
the
Lord's
yes.
question unfortunately prompted that further point.
Yes, I mean that's a somewhat different point, of course, but
it is, but it's also relevant if you're
yes.
You know, put it this way. Do you apply the concepts that we're dealing with in Section 29 in exactly the same way pre-dissolution and post-dissolution?
Shall I respond to my lady or my
so,
lord first? Well, can I actually do it the other way around, because always sensible to face the most recent cricket ball. the short answer, possibly not one that is going to be regarded as intellectually satisfying, but one which in this court may be regarded as adequate, is that in Don King, this court approved what had been said by Vice Chancellor Pennycook in a case called Thompson, and also followed what was said by the High Court of Australia in Chan and Zachariah, to the effect that the duty under Section 29, or the equivalent as it was treated in Don King, just as if it was under common law, continues the same irrespective of dissolution. The duty of a partner to account for the use that he makes of partnership things is the same, and I'll take you to that, but paragraph 40 from memory of Don King, but we'll get there in a more structured way, possibly not today. So in answer to my Lord Justice Snowden's point, the number one, of course, the selling a business was and capitalising it, realising it in that sense, is a way of giving the partners their rights, giving them their due. It doesn't follow that that is the only way, obviously. So the fact that on a sale you have to have whatever is possible in terms of the things that are sold and the conditions of sale that give value to the exercise doesn't exhaust the concept of accountability for benefits derived from use of the partnership resources, if I can use that in a neutral way to encompass all of the list in Section 29. When you enter into a sale, though, as I said earlier, it is possible to attach to the sale of, e.g., a name, something which plainly can be sold. It is possible to attach to it protections, whether those implied automatically by law or those which naturally follow as a matter of business practice, which ensure that the vendor can extract value from the intangible aspect of the connection.
I get that, and I understood your explanation. What I didn't hear, and it may just have been me, but I didn't actually hear the answer to my previous question about ACON and what you could sell in relation to as regards the relationship with ACON.
So what
You gave me lots of other examples of things.
Sorry, yes, I don't
think you gave me the answer.
No, I think I may have been deflected by some other considerations, but what could you sell? 2 points. Number one, this isn't the statutory test in itself, but number two, you could sell, for example, an exclusion of the seller from contacting ACON. If your lordship's asking me simply, could you monetize it? You could if you were selling, if the partnership was being wound up and you wanted to realise value, the partners could agree not to have any dealings with ACON. That would be a way to give value to it. So you'd sell, take this case, and you can see that sort
That's
of
not
process.
selling the relationship with ACON, that's selling the absence of it. So are you suggesting that you find a third party and say, I'm not sure what you're actually selling there, but you're saying that both of us will promise not to contact ACON. What are you actually selling?
So
That's just taking a
would be-
personal covenant.
My lord, with great respect, this is not the statutory test, but just to engage with your lordship's point, you sell the name, so you sell the brand.
I understand the brand.
Yes,
because
no,
as you
but,
say,
but then around that, but that brand has some value because it's a channel to the market which is established. So some people recognise it, it's known. Around that, you then exclude everyone else who's been previously involved from dealing with ACON or from dealing with customers, so that you say you're going to stay out of the field, and in that way, what you sell is in terms of the legal interest that's transferred is the name, but you protect that by ensuring that there are negative conditions that mean that you as the purchaser aren't going to find your acquisition and the commercial benefit you hope to gain completely undone. To take another case.
I'll look at the transcript, because at the moment I think what you've described is not selling the relationship with Acon. You're saying that the people who are the partners will not deal with Acon, and it'll just be for the purchaser to make their own arrangements with Acon. That's not selling the partnership's relationship with Acon.
But I didn't suggest that. I mean, there may be a way, I'll reflect overnight, in which you could sell it. But I'm saying, your lordship asked me, how could you monetize it? That's how I understood the question.
Because I got into this because I mean, we've all over the course of the last few days, I think, been looking at the wording of section 29, where you have property, name, and business connection. We seem to be gravitating to a point that they need in some way to be, I'll use the word belong, but they need to be the partnerships. Okay, I won't use the word belong. Whatever it is, it needs to be the partnership's business connection, the partnership's name, and the partnership's property. You say it's not technically belonging, but it needs to have some sort of
Association.
You, in fact, earlier on attached the word asset to the collective, those three in
Yes.
your submissions, and I was thinking that if we are looking for an underlying concept that section 29 is supposed to be embodied, and it is, that until there has been the completion of the winding up of the partnership's affairs, involving the realisation of all its assets, one partner can't use the partnership's property, name, or business connection without making an account. But that presupposes that the things that they are prohibited from using without making an account, or without giving an account, are things that could feature in that process of winding up the partnership's affairs.
That's perhaps where there's a nub of a difference between us, my lord. I don't accept. I think there is, with great respect, a danger that your lordship is going into a separate point that doesn't arise, not necessitated by section 29. Section 29 doesn't say that you can only be accountable for benefits of a kind which could be sold. It asks a different question, which is, has there been a benefit derived from the partnership's business connection by one of the partners? And it may well be the case in a partnership that you can't feasibly sell on it may or may not be the case, but it may be the case that in certain circumstances you couldn't feasibly sell on the benefit of the relationship which the firm had managed to build up. But that doesn't mean that if one of the partners exploits that relationship and derives a benefit, he's not accountable to the others. That is what section 29 says. If you want to run your business in a different way, then you don't form a partnership, you form a company and you try and invest all of the goodwill and the value in that corporate entity, and then that allows the sort of transmissibility in an easy way. And in a sense, that's why companies broadly replaced one of the reasons why companies replaced partnerships, not just limited liability, but as a vehicle, vessel, holding the assets. But it doesn't follow that because the goodwill or the business connection or the asset or advantage, to use the phrase that I used earlier, asset or advantage, doesn't follow that because it can't be feasibly sold and capitalised vis-a-vis the outside world, that there is no liability under section 29. That, I would suggest, with great respect, would be to engraft another limitation onto section 29, which simply is not there. And the principle in section 29 is that partnerships will generate things, resources, assets or advantages of commercial value. And if one partner uses those and derives benefit, then that partner is liable to account for the others. And this is a mutual liability, so it applies to everybody. When you go into the partnership, you don't know whether you're going to be a giver or a taker under this. It's very different from a director in a company where the director is a giver of fiduciary obligations. The partnership is mutual. So you can't look for an equation between a company and a partnership in that context, even though they both involve fiduciary duties evolved by the courts of equity. But the mutuality means that there's a different lens and a different focus that applies all along. And that section 29 applies to everybody. And if Mr. Hughes had wanted at the start of the proceedings to make a claim against Mr. Manduka. He could have done so, but for a variety of reasons he chose not to do so. By the time that he eventually brought forward a general post-dissolution claim, it was too late. But the fact that it might not have been possible in some hypothetical to sell the partnership on the 27th of June or at any date to some third party, it may or may not have been, with appropriate protections, etc. In the circumstances. The court didn't hear any evidence on that, but that's not the touchstone of liability under Section 29. And if we interpret business connection to mean, on the plain meaning of the words, a business relationship, a commercial relationship, or as I said, the collection of the firm's business relationships, then we say it's undeniable that Aecon was such a was part of that connection, because there was plainly a relationship with Aecon, and the extent to which benefit is derived from it is a matter for trial too. But if the position is that Aecon are selective about who they deal with, then obviously there's a significant benefit that's derived from it. If we go to the newsagent example, and it's just, I mean, it is obviously a very, very long way away, and we would say with great respect, it's useful as illustrating a point at the other end of the spectrum. From this case, worldwide pandemic, scramble for ways to deal with it. A supplier who got all sorts of validations, reliable tests, lifeblood in one word, gold dust in another that the judge also cites in paragraph 127. There is a relationship with that supplier. So would it have been possible to monetize that? Quite possibly, but it's still not the test, because the test is, was that then used? And it was used both when, in the months afterwards, you saw Mr. Hughes accompanied by Mr. Butcher going out on the road and telling people, I can sell you Aecon tests, here's the literature. No one else can sell you, sorry, I can tell you Hughes tests, here's the literature, but they're made by Aecon. Here's the literature, here's the validation of the Aecon test, etc. All of that advantage that he got from the partnership. And it was also used in relation to the Danish deal, which had been lined up, the opportunity to receive which had been lined up by the placement of a test through CAP, the business contact, whether or not it was a connection, but at any rate, somebody who had a contract with the partnership lined up such that when the penny dropped, it came through to Mr. Hughes, because Mr. Hughes was the person who was going to be contacted as, in effect, having taken over, or in the judge's words, seamlessly continued the business. And we say there is simply nothing surprising about accountability in that situation. I see the time, but would it help if just in a few minutes I just made a couple of points about Section 46, or would you like me to break? I'm in your hands.
And no, keep going for a few moments, because I dare say you've got quite a lot to deal with tomorrow as well.
No, and I'm very happy to carry on until I'm told to stop. So we looked at least indirectly at the Vagliano case. Can we just turn that up? It's at tab 18 in the authority bundle. I don't know. I don't have these volumes, I'm afraid. I imagine it's volume 1.
Yes,
yes,
it is.
So that was about the Bills of Exchange Act 1882. There was a provision in the Bills of Exchange Act which dealt with the effect of a bill with a fictitious payee. And the you can see that alluded to in the head note. The natural meaning of the statute provided for one outcome, where there was a fictitious payee, and the previous case law was clear that the result was the other way. And I hope you won't ask me which way around it was, because I haven't yet managed to read enough. The speech that is always cited is that of Lord Herschel, and we can pick that up. He starts in our bundle at page 238. And at the top of 239, he refers to the conclusion which the majority of the Court of Appeal arrived at. And we needn't worry about it because the next break on the page, the conclusion thus expressed was founded upon an examination of the state of the law at the time the Bills of Exchange Act was passed. Prior authorities were subjected by the learned judges who concurred in this conclusion to an elaborate review, with the result that it was established to their satisfaction that a bill made payable to a fictitious person or his order was, as against the acceptor, etc., etc. And then bottom break on the page, he says, with respect for those judges, I cannot bring myself to think that this is the proper way to deal with a statute, such a statute as the Bills of Exchange Act, which was intended to be a code of the law relating to negotiable instruments. And just to forestall a point, that act said in its preamble to codify, this act says to declare and amend. This court in the Frontier case in 2025, Lady Justice Asplin approved what Lord Reed, that's the recent Lord Reed, sitting as a first instance judge in the Court of Session, had said in the Duncan case that Miss Hilliard took you to, that the same principles of statutory construction that Lord Herschel propounded on the Bills of Exchange Act apply also to the Partnership Act. An act to declare and amend is being treated as an act which at least partially codifies the partnership law. And so he said, I think the proper course is in the first instance to examine the language of the statute and to ask what is its natural meaning, uninfluenced by any considerations derived from the previous state of the law, and not to start with inquiring how the law previously stood and then assuming that it was probably intended to leave it unaltered, to see if the words of the enactment will bear an interpretation in conformity with this view. If a statute intended to embody in a code a particular branch of the law is to be treated in this fashion, it appears to me that its utility will be almost entirely destroyed, and the very object with which it was enacted will be frustrated. So you can't really declare the law if all the time you have to look in the rear view mirror. But he also says this, the purpose of such a statute surely was that on any point specifically dealt with by it, the law should be ascertained by interpreting the language used, said of us before, by roaming over a vast number of authorities in order to discover what the law was, etc., etc. Then he goes on to say, about 8 lines down, middle of the line, if, for example, he says, I'm far from asserting that the result may never be had to the previous state of the law. If, for example, a provision be of doubtful import, such resort would be perfectly legitimate, or if their words which have acquired a technical meaning will be used in a sense other than their ordinary one, the same interpretation might well be put on them in the code. These are examples only. What, however, I'm venturing to insist upon is that the first step taken should be to interpret the language of the statute. So, what one can get from that, the general principle that you start with the natural language, the further principle that only when a provision is of doubtful import do you go and look at the previous law. And thirdly, the point that I emphasised about where a point, a topic if you like, is specifically dealt with by the statute. And we say that's quite important because Section 46, as you know, and there was a similar provision in the Bills of Exchange Act, and that's pointed out in Duncan, I'll take you to the reference. Section 46, as you know, says that the rules of equity apply except so far as inconsistent. So the real question is, well, when is there an inconsistency? What's meant by inconsistency? It's something which this court looked at in a case called M. Young that Ms. Hilliard briefly took you to. I'll probably take you to it tomorrow. But we say where there has been a specific topic specifically addressed by a provision of the Partnership Act, then it occupies the field. It is a point in Lord Herschel's language, that is specifically dealt with by the statute. And the topic that's addressed here is, when is a partner liable to account for benefits derived by him alone, not through the firm? And the short point I'm making is, if you add on to the statutory language other conditions, even if you can find a foothold for those in previous law, that's inconsistent because it's putting on new conditions which Parliament didn't enact.
And I think that means it's a convenient moment.
Thank you very much.
It's at 10:30 in the morning.